Death. It's unavoidable. You're shocked, devastated, confused, and uncertain as to what the future holds. You're dealing with your grief over the loss of a loved one and the burden of managing all the financial and legal issues that must be dealt with when a loved one dies. Though you may not have completed the grieving process, you must now begin the probate process and take on some new and very unfamiliar obligations. Starting the unavoidable probate process, which must begin soon after your loved one's passing, can be an overwhelming and daunting task for most people. If your loved one had a will, or if they never did any estate planning at all, they will be required to navigate the probate court process unless they have a living trust or the size of the estate was small enough to avoid the probate court process. If there's a house involved, you will almost certainly have to open a probate of the estate. Before we go further, let's put a few of the myths about probate administration to rest. 1. You do not have to pay an attorney to open the probate estate. Your attorney will be paid from the estate's assets at the conclusion of the probate proceeding. 2. The administrator of the estate is not personally responsible for the debts of the deceased person. 3. Despite what you may have heard, if you are appointed as the estate administrator, you will not be overwhelmed with a lot of complicated and legal and administrative work because it will be your attorney's job to handle it. So, what is probate? Probate is the legal process for distributing a deceased person's property to their heirs and beneficiaries and settling any debts owed by the deceased person. The probate process carries out the instructions set forth in a person's will. If there's no will, the estate must follow state law with regard to who is entitled to be a beneficiary. As the person in charge of the estate, you are entitled to be paid statutory fees according to state law. The statutory fee is a percentage of the estate's total assets. That means that you will be paid the same fee as the attorney for the estate, except that you will have to do very little work and all of the heavy lifting will be done by the attorney. Additionally, there are many services which are considered extraordinary, and for those services, you may be paid an hourly rate over and above the state statutory percentage which you will receive. For the most part, all that you will be required to do is to provide information to the attorney and manage the estate's assets. After handling the funeral arrangements and the other immediate responsibilities of the deceased person, your next responsibility is to contact an experienced probate attorney. Let's go further into what's involved in the actual handling of a probate estate. When someone dies, what do you do about their property, their creditors, their taxes, medical bills, Medicaid liens, pets, and the family member who claims that the deceased made promises to give them certain gifts? Your first step would be to file a legal document known as a petition for probate with the court, which is meant to begin the process to open the probate estate. The purpose of the petition is to have you appointed as the administrator of the probate estate. Concurrent with the filing of the petition for probate, you must also arrange for a publication of the petition in the local newspaper, giving notice to all that the petition has been filed. This publication is also meant to give notice to the creditors of the deceased person that they have the right to file claims against the estate for any debts which they may be owed. If your loved one created a written will to provide guidance on what to do after they've died, courts will usually consider the most recent will signed by the deceased person to be the controlling will. The original of the will must be filed with the court. Upon the filing of the initial petition to begin probate, the court will schedule a hearing. And if the court has no outstanding questions regarding the filed petition, the judge will order that the petitioner be appointed as administrator of the estate. Written notice of the probate estate being processed must be given to various state agencies, such as the Franchise Tax Board, the Department of Health, and the Victims' Compensation Board. Unless you were able to obtain a waiver of bond from the court, you will have to locate a bonding company to have a bond issued for the protection of the estate. The court will also appoint an appraiser, known as a probate referee, who will determine the value of the estate's assets. The attorney and the estate administrator will be required to determine what the estate assets consist of, and certain assets will be submitted to the probate referee for appraisal. Finally, a petition for final accounting and distribution of all estate assets must be prepared, which essentially summarizes the affairs of the estate for the court. If approved, the court will issue an order permitting the distribution of the estate assets to the beneficiaries. If there is a will, the estate assets will be distributed in accordance with the will. And if the deceased died without a will, then the heirs are paid according to the family priority laws of the state of California. Yeah, it can be a lot to handle. While we've tried to give you an overview of the process, the problems arise in how the details are handled. Making sure that you hire an experienced probate attorney will be your best bet to get through the probate process smoothly and efficiently. We at the Hayes Law Firm can help you successfully navigate this legal maze and prevent you from making any costly mistakes. Thank you everyone for tuning in to our video. We hope you found this information helpful. For more information on the probate court process, register for one of our upcoming probate webinars by clicking the link in the description below. If you are the administrator or intend to be the administrator of a probate estate, call our office for a free consultation. Thank you.